I'm Ben Meiselas with the MeidasTouch Network, and this is a breaking news alert. Supreme Court Justice Clarence Thomas has responded to Donald Trump's motion to vacate the 11th Circuit's order staying Judge Eileen Cannon's ruling, which returned the 100 classified records to the Department of Justice as they requested in their motion to stay. Donald Trump filed a motion to vacate earlier on Tuesday with the Supreme Court, requesting that the Supreme Court vacate the stay or the ruling by the 11th Circuit. And shortly thereafter, on Tuesday evening, Supreme Court Justice Clarence Thomas responded, and Justice Clarence Thomas set a deadline for the Department of Justice to respond to Donald Trump's motion to vacate by Tuesday, 5 p.m. Eastern Time. Justice Clarence Thomas is requiring the Department of Justice to respond to Donald Trump's application to vacate the 11th Circuit by Tuesday, 5 p.m. Eastern Time. Now, you may be saying, why in the world is Justice Clarence Thomas involved? I did a deep dive into this in the prior video where I talked about the application to vacate that Donald Trump filed, which was specifically addressed to Justice Clarence Thomas. But there is a little known procedure within the Supreme Court practice whereby the United States Supreme Court Justice who is assigned to a specific circuit court can make temporary emergency orders where certain factors are met. These are temporary orders pending the overall Supreme Court granting of certiorari, which means the Supreme Court hearing full oral argument on a specific case. But a specific Supreme Court justice assigned to a circuit could step in if they are petitioned and either stay the circuit court ruling or vacate the circuit court ruling. And here Donald Trump is asking Clarence Thomas to vacate the ruling by the 11th Circuit. So as I explained, the United States Supreme Court assigns or allots individual justices to oversee the 13 different circuit courts and to receive applications to stay or vacate decisions from a particular circuit. Justice Thomas has been allotted responsibility for applications made within the 11th Circuit. This allotment that he was given significantly precedes any of these events relating to the search warrant executed at Mar-a-Lago on August 8th. There are a number of factors that Justice Clarence Thomas will have to find if he is going to unilaterally intervene to make an emergency order vacating the stay by the 11th Circuit. It should also be noted the 11th Circuit that made the ruling, which stayed Judge Eileen Cannon's ruling and returned the top secret classified records, was comprised of 2 Trump judges and 1 Obama appointed judge who reached a per curiam, a unanimous decision that they all collectively wrote saying that it was self-evident that Judge Eileen Cannon is incorrect. And just so you know what the factors are that Justice Thomas would have to find, 1, there is a reasonable probability that 4 justices, other justices, will grant certiorari or agree to review the merits of the case. 2, that there is a fair prospect that a majority of the court will ultimately conclude upon review that the decision by the 11th Circuit on the merits was erroneous. 3, that there would be irreparable harm from the denial of the stay. And finally, in close calls, the circuit justice, in this case Clarence Thomas, may find it appropriate to balance the equities by exploring the relative harms to the applicant and respondent, as well as the interests of the public at large. So those would be the factors likely that the Department of Justice is going to address when they have to respond on Tuesday. Now, you may be saying, why in the world is Justice Clarence Thomas not recusing himself where his wife was inextricably intertwined with the events. I'm probably understating it there, was one of the leaders of the insurrection to overthrow our democratic institutions. Her involvement in directly communicating with Donald Trump's chief of staff, saying that she was going to bring the army if she could just have enough time. She talked about releasing the Kraken. Those are messages she sent to Mark Meadows. She said a number of other weird QAnon conspiracies about election disinformation to Mark Meadows, and was a major spreader of the big lie. She also reached out to state legislators and told them that they should vote contrary to what the actual electors are. She tried to recruit, in essence, the fake electors who submitted themselves to the National Archives, which submitted him, or was supposed to submit him, to Mike Pence, and that plan was ultimately foiled when Pence wouldn't go along with it. But she was intimately involved in that fake electors where they wanted Pence to reject the actual electors based on the votes of the people and install these fake electors. Ginny Thomas, Justice Clarence Thomas' wife, referred to that as we need clean slates. And she put this in emails with multiple legislators that the January 6th committee unearthed. So why in the world is Justice Clarence Thomas, whose wife is an insurrectionist, not recusing himself in a case where Donald Trump stole top secret confidential information, likely as part of a plot and a long-term plot to overthrow our democracy? The fact that I'm even saying that that is a scenario that exists, that that is actually taking place, just goes to show you how the Roberts Court, Chief Justice Roberts, appointed by George W. Bush, is completely out of control. The John Roberts Court completely out of control that this even takes place. And in terms of recusal, the Supreme Court is a self-governing entity. So they decide their own conflicts of interest. And here, Clarence Thomas is clearly not finding that he has a conflict of interest, despite the open and obvious conflict of interest exists. That's why as soon as Clarence Thomas even didn't reject what the application that Donald Trump filed outright, the fact that he's even involving himself and ordering the Department of Justice to do anything, to me is just a scar, another scar on this Supreme Court that has frankly lost its legitimacy based on conduct and actions like this. And so there are some legal analysts who say, well, look, the fact that Justice Clarence Thomas has set this briefing schedule for the Department of Justice to respond by Tuesday at 5 p.m., next Tuesday at 5 p.m. Eastern Time, that shows that he's likely not taking the urgency of Donald Trump's application to the Supreme Court seriously, because during this time, obviously, the Department of Justice can continue to pursue its criminal investigation and do the work it needs to do. So if Clarence Thomas found an urgency here, wouldn't he be scheduling this earlier? Sure, I understand that logic, but my immediate reaction when Justice Clarence Thomas immediately set this briefing schedule is, why the hell are you setting a briefing schedule? The answers, the legal analysis is so obvious that Donald Trump's application to the Supreme Court to vacate the 11th Circuit Court of Appeals per curiam order is so frivolous that the very essence that he's requiring the Department of Justice to issue a response, to me, just shows how, again, problematic, we'll use that word, problematic, this current composition of the Supreme Court is. Now, what are Donald Trump's arguments? Donald Trump's arguments are fairly incoherent in his brief. Like, the fact that this is even being considered by a Supreme Court justice is beyond absurd. And what Trump is arguing in his brief to the Supreme Court was that the 11th Circuit is basically a bunch of idiots. I'm breaking it down in layman's terms. And that the 11th Circuit had no appellate jurisdiction to even provide appellate oversight over the rulings of Judge Eileen Cannon. Because they argue the 11th Circuit can only intervene at an interlocutory stage, meaning before there is a final judgment, in very specific cases that involve injunctions, for example, as one example. And there's a bunch of other scenarios. But here, what Trump argues is that the appointment order for the special master is ultimately non-appealable, and that the Department of Justice appealed the wrong order, and therefore the 11th Circuit should not have even asserted its jurisdiction. Now, the 11th Circuit disposed of that argument right away when Trump tried to raise that when the arguments went before the 11th Circuit to issue the stay, which they ultimately did. And they said, of course, we have jurisdiction. Judge Eileen Cannon issued an injunction. The injunction was to stop the Department of Justice from utilizing their records, including their top secret classified records in connection with a criminal investigation, and requiring that those records go in front of a special master and not be returned to the Department of Justice. That's clearly injunctive relief. And that injunctive relief is inextricably intertwined with the special master appointment order, such that the 11th Circuit Court of Appeals would normally and typically get involved where there's a district court order telling the Department of Justice, or any party, frankly, that they could or couldn't do something on the basis of an injunction. So this is what Donald Trump is arguing to the Supreme Court. There's no jurisdiction in the first place. Now, one of the things I also mentioned, though, which is a procedural issue, which the Department of Justice will undoubtedly point out, is that after the 11th Circuit made its ruling and issued its stay, Judge Eileen Cannon then actually amended her special master appointment order so that the documents, the 100 classified records, were no longer part of her special master appointment order. So in essence, as I see the issues, Donald Trump's appeal is moot to the Supreme Court here, or the application to vacate the stay is moot, because Judge Eileen Cannon has now changed her order, and her order actually provided for the return of the documents. And what Donald Trump likely could have done if he wanted to challenge that is maybe challenge Judge Eileen Cannon's practice of doing that, but or challenge her order when she amended the order. But as I see it, the issue is moot, and to me, it's a no-brainer that the 11th Circuit could have jurisdiction here. And if Clarence Thomas were to rule that the 11th Circuit does not have jurisdiction here, he would severely be cutting off the appellate jurisdiction and power of the 11th Circuit, which, by the way, is a fairly right-wing, that's its reputation, appellate court. And so he would be undermining the ability of the appellate court that often right-wingers rely on to try to bail out Donald Trump here, which I wouldn't put it past Clarence Thomas to do. But those are basically the facts in sum. Apologize if it was somewhat long-winded, but I had to give you all of the factors. So finally, in summary, what happened? Donald Trump filed on Tuesday a motion to the Supreme Court. Actually, it's an application to vacate the order by the 11th Circuit, which stayed the district court's order that was an injunction stopping the Department of Justice from getting its records back. Donald Trump basically says, I should have these records, or they should go to the special master right away, despite the fact that the 11th Circuit ruled to the contrary in a very blistering opinion. Justice Clarence Thomas is the Supreme Court justice allotted to the 11th Circuit. So he hears emergency rulings. He's got an emergency request by Donald Trump. He set a briefing schedule for next Tuesday where he's requiring the Department of Justice to respond. Now, Clarence Thomas on his own can issue the emergency order, number one. Two, he can refer the matter to the overall Supreme Court, to all of the justices to make a decision. And then even if Clarence Thomas makes the order, here's an important part. The overall Supreme Court can then review that order and can overrule Clarence Thomas. But regardless, the order by Clarence Thomas, to the extent he did order that the 11th Circuit vacate their stay, then there could be oral argument, or there would be oral argument pretty soon, or as soon as the Supreme Court will take it up, on a certiorari where the Supreme Court will hear oral arguments with respect to the ultimate decision and the Clarence Thomas's order, the 11th Circuit's order. Now, one final point that I think is very important here is the following. The Department of Justice has already filed a motion to expedite their appeal of Judge Aileen Cannon's overall assertion that she has equitable jurisdiction. So to date, where the Department of Justice has been successful, is they argue there was irreparable harm and the document should be returned, but just those 100 classified records, because that's where the most irreparable harm would be, and there was an immediacy of an injury to the Department of Justice. But the 11th Circuit found that Judge Aileen Cannon did not have equitable jurisdiction over those 100 classified records. So the Department of Justice, in their motion to expedite their overall appeal regarding all the remaining records, says, look, 11th Circuit, you've already ruled she didn't have jurisdiction over these 100 records. The same logic applies to all of the remaining records. Judge Aileen Cannon, and I should never call her justice because hopefully she never becomes one, and she should never be a judge ever again, frankly, with her rulings. But the argument is 11th Circuit, Judge Aileen Cannon should never have asserted equitable jurisdiction at all, based on the 11th Circuit's prior scathing order, finding that none of the elements were established, that it wasn't even a close call, that it was self-evident that none of these elements were satisfied for Judge Aileen Cannon to assert jurisdiction over those classified records. The Department of Justice says your same analysis will apply to all of the remaining records. And I think it is a no-brainer. I think by mid to late November, I have a high degree of confidence. I think early December, the latest. But go back to this video. You'll see I think I'm right. The 11th Circuit is going to rule that Judge Aileen Cannon should never have asserted jurisdiction. And I think this whole special master process is going to be shut down. But I do want to shout out the special master because Judge Raymond Dearie, who's actually a well-respected judge, has made a number of recommendations, because that's all special masters can do, is make recommendations that can be accepted or rejected by the district court. And in most cases, they're almost always accepted unless the special master goes completely rogue because the district judge is appointing them to take those recommendations into account. But here, Judge Aileen Cannon has rejected her own special master, who is a distinguished former chief judge of the Eastern District of New York. She's rejected his recommendations, like that Donald Trump should submit an affidavit about whether the documents were planted or not, or whether the evidence log submitted by the FBI was accurate. She said, no. Plaintiffs, Donald Trump, who brought this case, he doesn't need to submit declarations or affidavits attesting to why he brought this case. Why would he have to do that? It's how corrupt Judge Aileen Cannon is. But I think she's going to be divested of jurisdiction sometime mid-November, early December. Here's all the things going on, though. So we'll see what happens on Tuesday with the Department of Justice's brief. I think they'll hit those points that I mentioned earlier in this video. We'll see what Clarence Thomas does. Regardless of what he does, his ruling is then reviewable by the full court. Then there could be a certiorari grant, which means the whole court can hear an oral argument and eventually overturn him if he just makes the most horrible ruling imaginable. But regardless, in the background, the 11th Circuit is going to rule on the overall appeal regarding Judge Eileen Cannon's wrongful assertion of jurisdiction. And now that Donald Trump basically called the 11th Circuit idiots to the Supreme Court, the 11th Circuit is going to be like, look at this game playing. Like, this guy's calling us out to the Supreme Court and saying that we didn't even have jurisdiction. He's basically calling us idiots. All right. We see what you're doing. They're not going to appreciate that move. And I think they're going to very quickly say enough of this charade. This is absurd, but we will see. I'm Ben Meiselas from the MeidasTouch Network. Hey, hit the subscribe button right now. We're almost at 1 million subscribers thanks to you. Help us get there. It's free to hit the subscribe button. Did you know that? Also, if you want to support the MeidasTouch Network and help grow this network, I always get asked by you, what can I do? Whatever country you're in, whether you're in the United States or abroad, and you want to grow this network, we take no outside investor money, period. That is how we stay 100% independent. But if you want to get involved, here's how you can help. Go to patreon.com/MeidasTouch. patreon.com/MeidasTouch. There's a number of membership tiers with exclusive benefits. You could become a producer of the MeidasTouch podcast and have your name appear. Get postcards for me and my brothers. We have exclusive podcast content there, other behind the scenes footage and more. Check out patreon.com/MeidasTouch. It goes a long way to help grow this network. Until next time, I'm Ben Meiselas from the MeidasTouch Network.
MeidasTouch is unapologetically pro-democracy. And look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs. It wasn't rigged, you're just a loser. At store.meidastouch.com. That's store.meidastouch.com.